hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today, let us learn and enter into the series of Public International Law. Today's topic is International Treaty. Treaties are increasingly utilized to regulate relations between international persons in the modern international law. Treaty is the generic term used to embrace convention, agreement, protocol, exchange of notes, arrangement, and declaration. A treaty is an agreement between international persons creating contractual rights and obligations. In a layman's language, we can say international treaty is nothing but a contract, but in the international standards. Before 1969, treaties were based on the customary rules of international law. The fundamental principle lying the maxim pacta sunt servanda, which means agreements between the states must be respected, forms the foundation for law of treaties. These customary rules regarding treaties were codified in the year 1969 in the form of Vienna Convention on the Law of Treaties 1969, and it applies only to the written agreements between the states alone. So, till 1969 treaties were only based on the customary rules of international law, but after the Pacta Sunt Servanda has come, because they are respecting the agreements which are already agreed by the parties, they have to be done. So, in the Vienna Convention on the Law of Treaties, only the written agreements between the states are considered. Let us get into the definition of a treaty. A treaty is an agreement or a contract entered into between two or more states or between international organizations creating legal rights and obligations between them. So, treaty is nothing but an agreement or contract between two states or two or more states, and they have legal rights and obligations. We have Article 2 of the Vienna Convention on the Law of Treaties 1969 defines a treaty is an international agreement concluded between states in the written form and governed by international law. So, the treaty is always a written document. Article 102 of the United Nations Charter also says that only just writing is not enough. Every treaty and every international agreement entered into by any member of the United Nations has to be registered with the Secretariat and published by it. If it is not done, the treaty agreement cannot be invoked before United Nations or International Court of Justice. So, in the treaty should be a written agreement and the treaty should be registered in the Secretariat. These two are the important parts of a treaty. So, what are the functions of these treaties? Treaties means nothing but agreements which have binding nature. So, law-making treaties are the important source of international law. The bilateral and multilateral treaties discharge the function of regulating international transactions, and they have the binding force as they are in nature of contract. Some treaties create constitutional law. For example, the International Conference in 1945 at San Francisco framed the Charter of United Nations. So, these treaties are some kind of agreements between two or more states, and if two states are involved, it is bilateral treaty, and if two or more states involved, it becomes a multilateral treaty. These treaties help each and every states which are having contract or which are having agreement with each other for the smooth functioning between the states. So, what are these law-making treaties? Law-making treaties are multilateral, which are the main sources of international law. So, as we have already said, treaties are of two kinds, multilateral treaties and bilateral treaties. Multilateral treaties involve many states, and this becomes the source of international law. The multilateral treaties express the will of several states in the international community. For example, the Declaration of Paris of 1856, Hague Convention of 1907, Charter of United Nations, all these are multilateral treaties. But bilateral treaties between two states are in the nature of private contract because they are only between two states and not of the international law. Example, the treaty between the development of St. Lawrence waterway between the USA and Canada. Law-making treaties are not passed by any legislature of the state. They are only the agreements or conventions drawn at conferences or congresses of the states which are represented by their plenipotentiaries. Because these laws are not made by the legislatures, but the states sit and discuss what are to be made in the treaty, and these treaties are represented by a common mouth. But as they have no powers delegated to them to take final decisions, these conventions cannot be final and binding unless they are ratified by the member states. It is open to a signatory state to give a notice to the other member states to denounce or to withdraw from the convention. So, the convention or a treaty or the charter is open to all who are participating in the multilateral treaty. If they are liking that treaty, they are welcome, and if they want to withdraw, they can withdraw from the convention. How can the termination of treaties be done? Treaties can be terminated either by operation of law or by the act of parties concerned. Same how we studied in the law of contract, same in that way we have two methods of termination of treaties. One is by operation of law and other by the act of parties. By operation of law, if one of the parties become extinct, for example, in one country or one state extincts and the successor state takes it into consideration, then if it accepts the treaty obligations, then if it doesn't accept the treaty obligations, then the second one is a treaty may cease to operate upon the outbreak of war between the two parties. The general principle of international law is that the violation of the treaty by one party makes it voidable or subject to cancellation by the other party. The first thing is by the extension of the state. The second is upon the outbreak of war. The third is a material breach of a bilateral treaty. If there is any breach in the contract, automatically it gets suspended or terminated. The fourth one is, according to Article 61 of the Vienna Convention, a treaty can be terminated with the object of the treaty indispensable for its execution and is destroyed, and its performance becomes impossible. Same as we studied in the case of law of contracts, when there is impossible, when something is very impossible to perform, then that treaty can be suspended or that treaty can be terminated. According to Article 64 of the Convention provides that if new temporary norm of just cognizance emerges, any treaty existing or which is in conflict with the norm becomes void and the treaty can be terminated. So, if the treaty is against some norms, then the treaty can be terminated. A treaty for a specific period of term terminates on its expiry. If that treaty is for a period of 2 years or 3 years, after the termination or after the expiry of that time, it gets automatically terminated. If successive denunciation, that is notice of withdrawal of multilateral treaty, reduces the number of state parties to less than the number prescribed for its coming into operation, the treaty may cease to be operative if such a provision has been made in the treaty. This is in the Article 55. So what it says is, if in the multilateral treaty, if the number of parties or number of states which are in the multilateral treaty, the number is reduced to the minimum, or then, and if it is written in the treaty that if there is a minimum less than minimum number of states in this agreement or in this treaty, then this treaty ceases, or this treaty extends, or this treaty gets terminated. So all we have is 9 kinds of circumstances. If the state gets extincted, and if there is a war, if there is a material breach, if there is a execution which if there is a, for the treaty, the thing has to be the performance is very impossible. And the other one is, if there is a new temporary or new norms has been executed, and if the time period has expired, and if they want to withdraw from the treaty and the number of parties have reduced to the minimum, and it is dissolved by the mutual consent of the parties, and the treaty can be terminated by the change in the circumstances according to the principle of rebus sis stantibus. So in all these 9 methods, a treaty can be dissolved or terminated by operation of law. What is by the act of parties? The second method of termination is by the act of parties. A treaty may be terminated or withdrawn from the party which may takes place in conformity with the provisions of the treaty. What are the provisions provided in the Article 54 of the Vienna Convention? If they can terminate according to the will and wish. A treaty may be terminated if the parties to it agree by the subsequent treaty and the subject matter of the treaty be governed by the subsequent treaty. A treaty can be terminated by denunciation, that is by giving notice to other party that it intends to withdraw from the treaty. But in that case, a treaty must provide for denunciation. So, in these 3 methods by the act of parties, the treaty can be terminated.